Welcome to Employment Law This Week. I'm George Whipple. Our top story, new legislation introduced in Congress on employee mobility. Congressional Democrats have introduced bills in both houses targeting practices that curb competition between employers for workers. The legislation would effectively ban no-poaching agreements, which are, in most cases, already considered a criminal antitrust violation by the Department of Justice. But the bills go further to ban anti-competitive corporate mergers and prohibit non-compete agreements except in limited circumstances. Jonathan Brenner has more.
Undoubtedly, the new legislation would require many employers to fairly significantly retool their employee hiring and onboarding practices and their contracts that are in use with many of their employees. Another impact is in the enforcement area, as the new law apparently would give new enforcement powers to the Federal Department of Labor for the prohibited activities. Right now, government fines, investigations, and audits are not things that employers have to contemplate with this kind of activity. The proposed legislation does not have bipartisan sponsorship. It has only been introduced by Democrats at this point. That could change, of course, but unless it does, the prospects for passage may be slim.
We'll have more on employee mobility next week, so stay tuned. California changes its test for independent contractors. The California Supreme Court has adopted the so-called ABC test, used in some other jurisdictions for determining whether a worker is an independent contractor or an employee. California workers will now be presumed to be employees unless an employer can establish otherwise using the three-pronged test. California businesses that utilize independent contractors should review those relationships in light of the change. To keep up with federal and state-level wage and hour changes, download EBG's app, the Wage and Hour Guide for Employers. Emails among employees about the terms and conditions of employment remain protected by the NLRA despite the use of profanity. An NLRB panel found that a restaurant in New York City violated the act by firing 4 employees following a group email that criticized some company employment practices and policies. The employer contended that the employee's actions were not protected by the NLRA because the message contained profanity. The board disagreed and held that the email does not lose protection under the NLRA because of profanity, and that the employees were entitled to reinstatement and back pay. The Ninth Circuit sets the clock on Title VII suits. Title VII lays out a 90-day time limit for filing civil action suits once an employee receives a right to sue letter. Here, a barbershop employee filed sexual harassment and retaliation charges against her former employer. At issue was whether the 90-day clock began when the plaintiff received a right to sue notice from the EEOC or when she became eligible to receive one. The Ninth Circuit reversed the lower court's decision, finding that the clock starts upon actual receipt of the notice. Now it's time for our tip of the week. Carolyn Rincon, Senior Employment Counsel for Marsh & McLennan Companies, is here with some tips on evaluating bringing discovery in-house.
Consider the following when determining whether your company may be able to benefit from internalizing more of its e-discovery process. Assess the current state of affairs. You'll want to sit down with your key stakeholders and literally map out the process from start to finish. You'll probably begin with events that will trigger a legal hold, moving through preservation, collection, review, and eventually production. Doing this will allow you to identify gaps, inefficiencies, and significant costs. Avoid overly complicated tools and focus on the user experience. The right tool for your company may not be the one with all the bells and whistles. Benchmark with peers in similar companies. Finally, take the time to do it right. Understand that this process is time-consuming, but don't rush through it.
Thanks, Carolyn. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.